I will call this meeting of the Senate Judiciary Committee to order. I apologize for my tardiness. I was out front at the Denim Day press conference, for those of you who don't know. Today is Denim Day in the Nevada Legislature, where we wear denim in solidarity with victims and survivors of sexual assault and sexual violence. And I think it's a very important moment for us, and I appreciate your patience as I finished up that obligation before I came down here. But now we are ready to get started. If the Secretary will please take the roll.
Vice Chair Canizaro.
She's presenting in another committee. If you'll bring her present when she arrives, please.
Senator Orenshaw.
Here.
Senator Harris.
I think she just stepped out for a moment. If you'd mark her present when she's back.
Senator
Actually, just mark her present.
Senator Settlemeyer.
Here.
Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Here, thank you. We're going to go a little bit out of numerical order today to accommodate our guest presenters. So, Assemblyman Yeager, I will turn the floor over to you. Which hearing would you like to open first? All right. I will now open the hearing on AB 107.
Good afternoon, Chair Scheibel, members of the Senate Judiciary Committee. My name is Steve Yeager. I represent Assembly District 9 in Southwest Las Vegas, and it is a real pleasure to be in front of the Senate Judiciary Committee for the first time this session, and likely not the last time, but it is an honor to be here today and to present Assembly Bill 107 in its first reprint. Joining me here at the table, as you can see, and is Bailey Bordelin. She will be helping me to present the bill to you. I'll just have a very quick opening statement, and then I'll hand it over to her to take you through the provisions of the bill. Assembly Bill 107 relates to access to justice. Access to justice is important, and the inability to afford court filing costs should never serve as an impediment to having your day in court. Assembly Bill 107 is a bill that will improve access to justice because it gives the court more guidance on how to determine whether a person should be relieved from having to pay costs. And that is the statement I'd like to make. Chair, with your permission, I would like to hand it over to Ms. Bordelin, who will explain the bill, and then, of course, we would be available to answer any questions.
Absolutely, go ahead.
Thank you. Bailey Bordelin, for the record, representing the Nevada Coalition of Legal Service Providers. We serve on the Statewide Access to Justice Commission with the Judiciary, so this is an issue that has come up quite a bit. And so just to lay the ground a little bit, we already have these fee waiver statutes in place that allow the courts to waive the fees for someone who otherwise cannot afford to pay them, but there's not a lot of definition in what that reasonableness is. So what we found is just inconsistent results statewide, where one income or one situation may allow you to file in one courthouse without fees, but not in another. And we believe that looking through a 50-state survey, that these are the appropriate guidelines to put in to ensure equal access to justice and statewide consistency in that area. And I would note that this is particularly important for a variety of filing situations. We know that in the state of Nevada, a tenant has to affirmatively respond to an eviction notice and actually initiate that court proceeding themselves, and there's a cost associated with doing that. So there's a cost to being able to defend yourself in the judicial process. In a totally different scenario, you pay a high filing fee for a divorce in this state, and so we have victims of domestic violence who, if they do not meet that threshold, actually end up waiting a few months and trying to save the money in order to come back and file for that divorce that they need. And so we believe that these definitions that we would be adding into law would help in those situations to ensure some uniformity and some equity for that access to justice. So to walk through the bill, I would note that you'll see throughout that we've removed some of the formality language at the request of some of the judiciary. We've been working as a system throughout the pandemic to streamline processes whenever possible, and so we're no longer requiring a formal court order. Courts continue to do that, but should there be a way to automate these applications and streamline these applications, we want to give the courts the ability to do that in a streamlined fashion. And then the meat of the qualifications is in section 2. So I'll walk through quickly what those would be that you would qualify for a fee waiver. So the first one is if you receive federal or state benefits for public assistance. We believe that that has shown that you have already vetted your need for the financial waiver. Number 2 is we would set a 150% poverty level. I've submitted the poverty chart so you can see what those numbers are on Nellis. This is where I think we'll have some statewide consistency here. Different courts have set different amounts. And so in some courthouses, this would be a slight increase to who is currently qualifying. I would note the Las Vegas Justice Court currently has that set at 138%. So it is a slight increase in some places, but 150% is also what we use statewide for someone to qualify for free legal aid. So that way it would be the same population, whether they were able to access a legal aid provider or not in advance of their legal need, that wouldn't have to pay the filing fee. And then sections 3 and 4 allow for an individual review of a case and the individual need that someone may have if they haven't met those previous thresholds. So oftentimes we have a parent whose child is experiencing a medical emergency that is taking up a significant portion of their wages, but they otherwise look like they would be able to qualify. They could still lay out that fact situation for the courts to consider if they wanted to grant that on a case-by-case basis. And then the last one is an existing fee waiver that if you are a client of legal aid has vetted you because of our funding mechanisms that we serve people who have shown a financial need, so you would continue to not pay the filing fees if you're a client of legal aid as well. So with that, I think we're open for questions.
Thank you so much. And do we also have somebody on the Zoom to answer questions?
Bailey Bordelin for the record. I believe that Stephanie McDonald from Legal Aid is also on the phone, who works in the civil law, the Family Law Self-Help Center in Clark County, so she deals with a lot of these applications on the ground and can help answer some of those process questions.
Fantastic. Questions from members of the committee? Senator Settlemyre.
Thank you, Chair. I appreciate that. I was just kind of curious, what percentage of individuals do you think out there will qualify for this type of deferral type situation of having to pay for the court cost?
Bailey Bordelin for the record. We don't see this as a large change. I'm not sure if Stephanie can speak to what percentage of people are currently qualifying. I will note in my conversations with the courts, they didn't see it as a substantive change from the way that they're currently receiving fees, because it is just those little pieces of uniformity that we're trying to reach. So I don't have a number off the top of my head. I will pass to Stephanie, but I'll also note that a percentage of these fees do go to the legal aid providers in the state. So to the extent that there is an offset, it actually hurts us.
Okay, well, what percentage of legal aid clients, what did that apply to?
Bailey Bordelin for the record. If it's legal aid clients, 100% of legal aid clients are indigent, so they are already qualifying for the fee waivers.
Okay, thank you.
And I think we have a question from Senator Hansen as well.
Thanks, Madam Chair. Yeah, my question deals with section, on page 3, about the sheriffs. When I haven't done it in a long time, but I used to have to hire sheriffs to deliver certain legal processes, small claims actions and things like that. Typically back then it was $50 to $100. Last time I did it, I actually had to hire a private server, and it cost me like $200 because the person lived out of a certain zone. What is the, I mean, who's supposed to pick up the tab here for the sheriff? Does legal aid pay them on some kind of a basis, or because there is obviously a cost to the sheriff to serve the papers and take the time out to try to track people down and so forth?
Bailey Bordelin for the record. I'm going to have Stephanie answer that.
Hi, thank you. My name is Stephanie McDonald for the record. I'm attorney for the Family Law Self-Help Center down in Clark County. I don't think anybody necessarily absorbs that cost. I think it's part of the budget within the sheriff's going operating expenses. There, as Bailey said, this bill isn't going to create a large difference in the number of fee waivers being approved or filing fees that are being waived, as similarly wouldn't change daily operations much for the sheriffs. Last time I checked in Clark County, the fees to serve were running, they charge per document. So depending on how many documents there are that need to be served, I last checked, it was $20 or $30 per document. And then they also charge for mileage depending on how far they needed to go. So I think the average service fee from the sheriff for those who are paying them in full for that service runs between $50 and $80, just depending on, again, the documents and the mileage.
So there is a cost on that. And I'm not familiar with the whole program. I mean, the concern I had just reading it, how do you prevent, frivolous, redundant, vindictive type of actions? If there's no cost to the individual filing these things, what prevents them from just doing it in a way that, frankly, just trying to be obnoxious to their former landlord or whatever?
Bailey Bordelin for the record. Thank you, Senator. I would note that the sheriff language is pre-existing on page 2, and the bill is just kind of rearranged. So I think what Stephanie was referencing is that that's the process currently that the sheriffs are working with us on this. As far as filing, the court always has the ability to order that costs do be paid once the case has been opened, if they feel that the fee waiver wasn't justified.
Are there situations where this could be abused, or has it been? I mean, obviously I'm not an attorney. I'm not practicing like yourself. What prevents people from misusing this and just filing, an unlimited number of civil actions just to harass?
Thank you, Senator. It's not specific to somebody who can't pay, right? Anyone could pay to file a harassing amount of lawsuits as well. So there are mechanisms in the law that do address, I'm forgetting my law school term, but obnoxious filers. Vexatious litigants. We would use the vexatious litigant statutes.
Okay. Well, I'm just curious. I mean, I don't want to open the door to somebody want to go after their ex-landlord and make their life miserable for a while at no cost to themselves. Thank you, Madam Chair.
Sure. I think we have a question or comment from Senator Orenshaw.
Thank you very much, Chair, and Assemblyman Yeager and Ms. Bartola and Ms. McDonald. I appreciate the bill because from what I understand, it's not easy for someone to try to proceed, in forma pauperis and try to, jump through all those hoops. So I think that this will try to take some of those barriers away from people who need access to justice and need access to the court system. Whereas now, I think that the hoops, especially for people who are proceeding on their own without an attorney, are really difficult. So I appreciate the bill, and thank you, Chair, for allowing me to make that comment.
Of course. And I think I saw one more question from Senator Pickard. Go ahead.
Thank you, Madam Chair, and thank you both for presenting the bill. I mean, I deal with these all the time, and I'm interested, though, in understanding the difference between the existing state of informa pauperis filings and what this bill will do. Not so much from Clark County. They do a wonderful job. They've got the forms all ready to go. I think those in Clark County who avail themselves of the Self-Help Center will be guided right through the process, and they don't seem to have much of a problem. And certainly those clients that come to me and we decide to take them on, but they're indigent, we work very well with legal aid to get that done. So, but in areas where we don't have a good, solid self-help center or legal aid center that can help people through this, how does this change the process from the existing informa pauperis procedure and what this will do, other than, I completely agree that the additional detail under sub 2 that will give guidance to the court to identify who it is that we're going to grant this status to. I think that's a great idea, but how does this differ from the existing in the more rural areas where they don't have an outfit that's going to help them?
Thank you for the question, Senator Pickard. First, I would note that we do have a legal aid provider that technically covers every county, so if you need help, come find me. Secondly, something that we really like in this bill, in Section 1, subsection A, it says file on a form provided by the court. So I think, Senator Pickard, you're one of the attorneys who can appreciate what goes into creating a statewide form, and that Clark County does in fact have much more readily available self-help forms than the majority of the counties because of the work being done there. But we have successfully created a statewide form for domestic violence protection orders, for example. So I think the goal and the vision as we continue to work as the statewide Access to Justice Commission is to constantly increase when we can have statewide forms available, so that we're pulling along those other counties in terms of accessibility. And so we like the on a form provided by the court because we think that will help us reach statewide uniformity in helping people file.
All right, I appreciate that, and I presume that we'll be working with the the administrative office of the courts to get that done quickly, because if we just leave it up to the courts, they're slammed. I don't know how long that would take to get done, but I assume that they're part of the stakeholder conversations that have been had.
Yes, thank you, Senator Pickard, Bailey Bordelon, for the record. We do believe that we can quickly adapt the forms that we are using in Clark County and work with the judicial system to push that out.
Great, thank you, and I love the bill. I think it's a great idea to make sure we've got uniformity, and particularly given some judges just frankly are reluctant to do this because not because they're mean-spirited or anything. They just don't want to push the burden onto the county already. And so this will give some additional guidance and incentive to give these people the access they need. Thank you very much.
All right, other questions from the committee? I do not see any, so we will go to testimony in support of AB 107. Is there anybody in person or on Zoom to give in support testimony? It looks like we do have somebody coming up in support. Please go ahead.
Tanya Brown, Advocates for the Inmates and the Innocent. Good afternoon, Madam Chair, members of the Senate Judiciary. We support this bill, and I just kind of want to touch on something because I've had to, myself personally, have to sue someone over a situation. And a lot of people don't realize that a person who is the plaintiff and has to serve, they can actually have a friend serve the individual at no cost. So that's another way that they can get around it, and a lot of people, some people know that, some people don't. But I just kind of want to let you know that there are people that do it that way. I've had to do that with the real estate agency. Thank you very much and have a good day.
Thank you, Ms. Brown. And I didn't get confirmation. Do we have anybody on Zoom testifying? I'm going to take that as a no, and so we will go to the phone lines for testimony in support of AB 107.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 107, please press *9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 107, please press *9 now to take your place in the queue. Caller with the last three digits, 611. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the Senate Judiciary Committee. This is John Piro, Johnpiro, from the Clark County Public Defender's Office. And we just want to testify in support. Access to justice is a major issue, and we think that this bill helps increase access to justice. Thank you.
Thank you, caller. If you've recently joined us, we are currently on support testimony for Assembly Bill 107. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. And Chair, at this time, there are no more callers to provide support testimony.
All right, we will move to testimony in opposition to AB 107. I don't see anybody in the room to give opposition testimony or on Zoom, so we will go directly to the phone lines, please.
Thank you, Chair. To testify in opposition on Assembly Bill 107, please press *9 now to take your place in the queue. Once again, to testify in opposition of AB 107, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Okay, we will move to testimony in the neutral position on AB 107. I don't see anybody in person or on Zoom to give testimony, so we will go directly to the phone lines, please.
Thank you, Chair Scheibel. Excuse me. To testify in neutral standing on Assembly Bill 107, please press *9 now to take your place in the queue. Once again, to testify in neutral on AB 107, please press *9 now to take your place in the queue. Caller with the last 3 digits, 139, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
My name is Alex Falcone. I'm testifying neutrally. Just wanted to give some of my experiences. I filed in forma pauperis, I guess you could say, cases because it was not just in district court, but it was also in the Supreme Court on multiple occasions. And I just wanted to mention that my experiences with forma pauperis status were very heartening because I was a college student and I couldn't afford to litigate. I had very little income at the time. 4 of the decisions in the Supreme Court actually reversed, and 1 of the writ petitions that I filed in the Supreme Court actually published. So I wouldn't say that all of them were filed for free, but I would say about half, maybe 3/4 of those actions were filed for free. And those outcomes would not have been possible without forma pauperis status, 100% for sure, because I just simply could not afford to pay the filing fees. The other thing that I'd like to mention is that I, at one point, or on a number of occasions, tried to get the losing party to pay the costs as mandated by statute, and most of the time the judges were resistant to doing that. So I think I did hear some concerns from some of the legislators about abuses, and there is a statute that mandates an award of costs against the losing party, but it looks like it's going to be probably on the onus of somebody besides one of the litigants to make sure that those judges are ordering those costs are imposed against the losing party, and that could possibly help with some of the financial concerns some of the legislators had. And that's all I have.
Before you sign off, could you just clarify whether you're calling in support or neutral?
Chair, this is Bryce with Broadcast. He did log off. I can confirm it was a neutral testimony.
Okay, well, it sounded more supportive to me, but we'll just let the record speak for itself in 100 years when we go back to read it. With that, is there anybody else to testify in neutral?
Chair, at this time, there are no more callers to provide neutral testimony.
It's like I knew. And that concludes testimony. Do the presenters have any closing comments? It's not mandatory, but it's welcome.
Steve Yeager for the record. Thank you, Chair Scheibel. I just wanted to thank Ms. Bordelin and also our partners in the justice courts in particular. They worked very hard on this matter, and so I would urge your support and certainly available for questions after today's hearing if you might have any.
Ditto. Thank you, Chair Yeager.
Thank you both so much. That concludes the hearing on AB 107. That hearing is now closed. We will now open the hearing on AB 104.
Good afternoon, Chair Scheibel, members of the esteemed Senate Judiciary Committee. My name is Steve Yeager, and I represent Assembly District 9 in Southwest Las Vegas. It is my pleasure this afternoon to present Assembly Bill 104 in its first reprint. As you can see here at the table, joining me is Chief Deputy Attorney General Heather Proctor from the Attorney General's Office. And Chair, with your permission, I'd like to provide a little bit of background and then hand it over to Ms. Proctor to talk a little bit about the bill. To really understand this bill, we have to go back to Assembly Bill 267 of the 2019 session. Assembly Bill 267 from last session did something really significant. It provided compensation for those who had been wrongfully convicted and incarcerated in our state. Many people helped make that legislation a reality, and I'm very thankful for that. It was certainly a long time coming for the state of Nevada. Back in 2019, we heard from DeMarlo Berry, who had been wrongfully incarcerated for nearly 22 years, yet he was full of grace and forgiveness when he testified, and it remains to this day one of the most remarkable hearings I've ever been a part of in the legislative building. I'm proud that Assembly Bill 267 from last session had bipartisan co-sponsors and passed both houses unanimously and then was signed by Governor Sisolak. I tell you all of this because the bill in front of you, Assembly Bill 104, makes some changes to the law we passed last session. Those changes came as a result of feedback from the Attorney General's office, who is the one who actually defends or negotiates these lawsuits. They were able to provide suggested changes to make the law clearer and easier to administer. I will say it was an absolute pleasure to work with them on this bill over the last few months, and I'm very thankful for their collaboration on this issue. Chair, with your permission, I would now like to hand it over to Ms. Proctor to give you some additional background about how the Attorney General's office has been handling Assembly Bill 267, and then she can take you to the bill and will be available for any questions.
Good afternoon. For the record, my name is Heather Proctor, Procter. I am a Chief Deputy Attorney General with the Nevada Attorney General's Office. As introduced by Chair Yeager, on June 17, 2019, the legislature passed Assembly Bill 267, codified in NRS Chapter 41, which authorizes a person who is not currently incarcerated for any offense and who was wrongfully convicted and imprisoned in this state to bring an action for damages and other relief in any state district court. AB 267 became effective October 1, 2019. Since the enactment of the wrongful conviction compensation statutes, the Nevada Attorney General's Office has worked with claimants in balancing the state's obligation to be fair and just with its responsibility to ensure that it is not overwhelmed with an enormous monetary liability. To that end, the office ensures every claimant complies with NRS 41.900 and establishes by a preponderance of the evidence that they did not commit the crime for which they were convicted. As with any new law, through enactment, the Attorney General's Office discovered that the existing law required clarification, uniformity, and certainty for the state and claimants alike. This led to the proposed amendments in AB 104. To be clear, the intent of the wrongful conviction compensation statutes, as addressed in the 2019 legislative history, is to provide monetary support for persons recently released from incarceration to permit them to begin rebuilding their lives, re-entering society, and doing what the state can to restore their dignity and life after years lost wrongfully incarcerated. An award does not place blame or find fault. Rather, the person is provided a chance to live a normal life with a certificate of innocence, permitting the claimant to move forward without the wrongful felony conviction looming in their background and at every traffic stop, and money to start that life and the necessary provisions of life, from medical care and counseling to advanced education to reentry and financial literacy programs. As many of these claimants are also seeking monetary compensation against a county or state agency through a Civil Rights 1983 action, which typically takes years to resolve, the law includes an offset provision requiring a claimant to reimburse the state for the money paid for the length of incarceration. Before I begin discussing the first reprint of AB 104, and to avoid confusion, I wish to clarify that there are three types of funds associated with wrongful conviction compensation case. First, the statutory damages based on the time the claimant was incarcerated and or on parole. Second, the attorney's fees, which are capped at $25,000, and third, the additional benefits. Section 1 of AB 104 revises NRS 41.910 to clarify the documents to be sealed following the issuance of a certificate of innocence and the confidential nature of such proceedings. Section 2 exempts the state from the restrictions of an offer of judgment, as well as prejudgment and post-judgment interest. Again, I return to the intent of the bill, which is to permit the claimant sufficient funds to restart their lives while they await larger settlement funds from civil rights matters without incurring unnecessary additional costs for the state. Section 3 provides clarification for the claimant and the state in calculating the statutory damages based on the length of incarceration. In implementing this law, the Attorney General's office determined that caps were necessary for the additional benefits a person could claim under the statutes. No caps currently exist for these additional benefits. We found, for instance, a person wrongfully incarcerated for 5 years would be entitled to a lesser amount of statutory damages for the length of their incarceration, but the same amount of benefits in both monetary value and length of award as someone wrongfully convicted for 30 years. A person should not receive benefits for a period that exceeds their original incarceration. Again, the intent of the statute is to give the person assistance in returning to normal life, not a lifelong windfall. In addition, the Board of Examiners requested some certainty in the costs that would be sought from the Reserve for Statutory Contingency account. This led to the additional proposed caps in Section 3, which serve to 1, clarify the costs a claimant can pursue, 2, maintain the assistance a claimant requires to return to normal society, and 3, create certainty for BOE to budget for the additional expenses by providing a maximum potential cost for these benefits each year. During the committee hearings on AB 267 in 2019, Assemblyman Yeager and the Innocence Project stressed that the payments under these new statutes were not intended as a double reward. Again, it was intended only to permit the claimant the ability to return to her normal life pending settlement of a 1983 action. It is possible for a claimant to commence a civil action in any state or federal court throughout the country, not just in Nevada. It is impossible for the Attorney General's office to track every claimant throughout every potential state or federal court for years to determine when and if the claimant receives another settlement related to their wrongful conviction. To that end, Section 4 clarifies the language of the offset provision to bring it in line with the original legislative intent. It clarifies for all parties what settlement funds are subject to the offset, and it establishes a time frame for the claimant to notify the state of subsequent settlements. Thank you.
Thank you so much for your presentations. Are there any questions from members of the committee? All right, Senator Hansen, go ahead.
Thanks, Madam Chair. Of course, the DeMarlo Berry case is, everybody knows about that one. I'm just curious, how many cases have been brought before the AG's office since the law was passed?
For the record, Heather Proctor, we have submitted an exhibit that lists all of the cases that have been filed to date. We have 8 at this time. We have settled 3. We have 2 in settlement negotiations, and the rest are currently in litigation.
And is there any certain jurisdictions that seem to have a disproportionate number of them? I represent 7 counties. I don't know if my DA is all doing a good job, and not. The concept is let 10 guilty go rather than convict 1 innocent. So I'm kind of just curious. That's actually a surprisingly small number. That's just a good thing, right?
It is. As to your question, of the 8, 1 was in Washoe County. The other 7 were in Clark County. I also wanted to clarify that for individuals who were wrongfully convicted prior to 2019, they have until September of this year to file their claims because they have a 2-year statute of limitations.
Good. Well, I'm totally supportive of the concept. Just horrible in my mind that we have ever convicted anyone, but things try to do the best we can. We're all human, but they certainly deserve full compensation and then something, if you ask me, when they've been wrongfully convicted. So, thank you, Madam Chair.
Yes, and I think we had a question from Senator Pickard. Go ahead.
Thank you, Madam Chair. And I agree with Senator Hansen. I think that this is good policy. I have a question, and it's just technical. I'm looking at Section 3 and trying to figure out how this would work. And the trigger event is the wrongful conviction or the release from prison, which is earlier. And Ms. Proctor, you actually touched on my question a little bit, and that's what happens when the person is out on parole. So they're technically released from prison, unless I've misunderstood that term, and it may be a term of art. Maybe they're still technically considered imprisoned until they're done with parole. But my understanding was that once they're released from prison and they're on parole, if that comes before the determination of a wrongful conviction, this would start at that time, at the release of prison. But then in the other instance, they may still be in prison and then may get the wrongful termination, wrongful conviction designation, but then they may not be released right away either because they may not have a place to go. So can you talk a little bit about why we've chosen this type of trigger and how it would work?
Certainly. For the record, Heather Proctor. As to your first question, Section 3, Section A, 1, 2, and 3 address the length of actual incarceration. Section B of that statute addresses the length of time on parole. So we actually take the length of incarceration, add the length of, make that determination as to which category they fall into. Then we add the number of years or months on parole with that calculation of the $25,000 per year, and that is the total amount of the statutory damages.
Okay, so perfect, because that was my follow-up question, because it seemed that because they were disjunctive in its construction, that we may actually see some overlap, but you just resolved that for me. The other question I had to do with the additional programs and counseling and whatnot. I'm assuming that when we're talking about these and we're talking about the costs of them, we're talking about programs that are held within the state, that we're not considering programs for counseling and whatnot that might be outside the state and beyond our control to control those costs. But is there a limitation as to where they can obtain these? Because my thought is this: some of these people may choose to relocate to family out of state, and yet they're still going to need some of these programs. Would this be available to them wherever they end up, or are there limitations on those things?
For the record, Heather Proctor, there are only limitations on the additional education through the Nevada system, and the medical coverage is through the accepted Medicare, Medicaid, or the Silver State Health Plan. None of the others have restrictions as far as where they're located.
But as far as those, and I'm specifically with respect to education and medical services, those must be obtained within the state?
Heather Proctor, for the record, the education, yes, that must be obtained through the state of Nevada. The health care is also limited through the state of Nevada.
Okay. I guess my only concern is, just as I stated, if they choose to live with family out of state because they don't have anybody here, they're foreclosed from obtaining those services. And so I thought that was kind of interesting, given those are two things that are probably the most important services that they're going to receive.
For the record, Heather Proctor, the restrictions on those two occurrences in the state were actually part of the original bill. So far, we have had one individual who has lived outside the state, and all the rest do continue to live within the state, but you do make a very excellent point.
All right. Thank you. I appreciate that.
All right. Any other questions from members of the committee? I don't see any. Thank you again, both. And we will move to testimony in support of AB 104. I don't see anybody in the room to give support testimony on AB 104. And I understand that there is nobody on Zoom. Therefore, we will go to the phones, please.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 104, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 104, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide support testimony.
Okay. Then we will move to testimony in opposition to AB 104. It looks like we have somebody in the room to give opposition testimony, so we will start with you.
Tanya Brown, Advocates for the Inmates and the Innocent. Thank you, members of this committee, for hearing this bill. We would normally support the bill, but we see some issues with this, and so we oppose AB 104. This bill has unintended consequences. To begin with, it denies full compensation to those who have been wrongfully convicted by not including the jail time they have spent awaiting trial. In previous testimony given, some individuals have been waiting for over a year to go to trial. In Section 3, subsection A 1, 2, and 3, the language, or the person was released from prison, whichever is earlier. To be released from prison, a person must be paroled, their sentence must have expired, or their life has expired. If a person's life has expired by means of natural death, lack of medical care, or has contracted a contagious deadly disease or virus, they are released from prison. If the person who has always maintained their innocence and they have an appeal pending, the appeal now becomes moot. It is over for them. Not only is it over for them, but their loved ones as well. Does the state of Nevada not care about actual justice because the person has died? Is the person's life now meaningless and insignificant? Is their loved ones' families' lives meaningless and insignificant too? These are some of the unintentional consequences of this bill. There is no other remedy to exonerate their names. In 2019, Assembly Bill 356, the Factual Innocence Bill, passed. During the Senate Judiciary, I provided a proposed factual innocence posthumously amendment to allow the families of those who have been wrongfully convicted an opportunity to exonerate their loved ones' names. This committee chose not to place it onto the work session. In 2011, the Nevada Supreme Court, in its decision to deny a petition for exonerated, suggested the legislature create a law to allow the courts to hear and grant petitions for exonerations posthumously. As of to date, that has not happened. However, with the passing of ballot question 3, the Pardons Board has now been asked to consider setting aside one Pardons Board hearing per year to allow pardons on factual innocence posthumously until the law is changed. I have, in the bill, there is an exhibit, the conceptual amendment to this. I would like for you to take a look at that and consider it. It deals in Section 3A. It also mentions the Pardons Board's commission has deemed he or she factually innocent posthumously. And also it deals with the amounts of monies. It should be calculated from the time of their arrest. And then also it states too, and it's a typo I meant to include, or if he or she was given a life sentence with or without the possibility of parole and died prior to 21 years calculation of the bill, the estate will receive the maximum amount awarded by the state of $100,000 for each year. Actually, if a person serves 1, 5, 10, 20, 50 years, and they die, whether they had parole with or without, they should be paid $100,000 for each year they've lost, and it should go to their estate. Not only have they lost something, their families, their loved ones have lost as well. And I ask that you consider this amendment to this bill. Thank you very much.
Thank you. I don't see anybody else coming to the table to give testimony in opposition to AB 104. So we will move to testimony on the phone in opposition to AB 104.
Thank you, Chair Scheibel. To testify in opposition of Assembly Bill 104, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 104, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 841, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Madam Chair, members of the Senate Judiciary, and Assemblyman Yeager. My name is Lisa Rasmussen, LISA-RASMUSSEN. I'm testifying on behalf of my law firm, Law Offices of Christina Wildeveld today. I really only have one small opposition to the bill, and before I explain that, I want to really thank everyone who's worked so hard on this. I have two of these cases. One we've just recently resolved, and the other one we're in the process of resolving right now. And it has been a pleasure to work with Heather Proctor and her cohorts in the Attorney General's office. And I've also spoken to Chairman Yeager about my specific opposition, although when we did speak, we were looking at a conceptual amendment that was slightly different than the one that came out. So here, and I want to say, I think all of these changes and proposed changes are good. They make common sense. I can tell this committee from working through these that these just make sense kind of all the way around. And these issues, other than the one thing I'm going to point out, aren't problematic. So the one issue I have is Section 3, subsection A, and it's kind of what Senator Pickard was touching on. It's subsection A, 1, 2, and 3, where it says the conviction was reversed or the person was released from prison, whichever is earlier. So when I was working on this with Chairman Yeager, the whichever earlier was not in the conceptual amendment, and I see that it's been added back in if I'm looking at the right thing. So I don't think the whichever earlier should be in there, and here's why. The minute an order comes from the Nevada Supreme Court reversing a conviction, the defendant, our client, does not get out of prison that day. There's a remitter that comes within the next 40 days. That actually makes it final. The remitter could be held in abeyance for a petition for rehearing or a petition for certiorari. That date is not the date that the prison doors open up and the person walks out of prison. What generally happens is they get remanded back to local custody, back to the Clark County Detention Center. So while I understand it's the state's position that once they're remanded back to local custody, they're no longer imprisoned under the wrongful conviction, while I don't love that, I do understand that the time prior to the conviction and the time when they're no longer laboring under a wrongful conviction is not counted. The problem is just in the detail here, whichever is earlier. So I would recommend that we remove the words whichever is earlier and just leave it at when the conviction was reversed or the person was released from prison. And that can mean different things in different cases. For example, one of the cases we're working on right now, it's actually kind of confusing because it's so old, trying to figure out when he was brought back from the prison back into local custody. And may make a difference of half a year at $75,000. So these are not huge differences, but in fairness to these defendants who were wrongfully convicted, it shouldn't go based on the date the Nevada Supreme Court orders something because the prison doesn't open the doors and say, hey, you're good to go, you can be released. It's just not the way it works. So, and in fact, people can be back in local custody for a long time as well. But that time doesn't count, but what we're trying to pinpoint here is when they're released from the prison, whether that's transport back to local custody or not, and that never happens the day of the reversal. So I think the whichever is earlier part should be removed. That's my suggestion. Otherwise, I would be testifying in support of it. And I want to thank everyone for listening to my comments and input.
Thank you, caller. If you've recently joined us this afternoon, we are currently on opposition testimony on Assembly Bill 104. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 556, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. I'm calling in opposition of the bill The wrongfully convicted have already suffered the ultimate injustice. The stigma attached to the conviction will plague them long after exoneration. Their nightmare begins day one at the false arrest, thus compensation should begin then as well, not at the time of conviction. Look at how long people are waiting for trial now due to COVID-19. 1 day in jail wrongfully convicted is wrong, let alone years. I would support Ms. Tanya Brown's amendment. If this bill passes, it doesn't appear to speak on that posthumously they are victims of the system more so than anyone when you die in jail wrongfully convicted. Given the new developments Ms. Brown mentioned, it's possible the Pardons Board may entertain posthumous pardon hearings. Governor Sisolak asked me for my documents that I spoke of when I made public comment at the last meeting, as I do public records requests and came across evidence that I do believe is newly discovered in some cases. The legislature won't be back again for 2 years. If these hearings happen at the Pardons Board, this bill may not protect all wrongfully convicted, whether alive or dead. These families of the wrongfully convicted still fight on, and if they pass away, and there is no compensation for that category. Justice is supposed to be for all. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide opposition testimony at this time.
Thank you so much. We will move to testimony in the neutral position on AB 104. I don't see anybody coming to the table in the room, so we will go directly to the phones.
Thank you, Chair. To testify in neutral on Assembly Bill 104, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 104, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 224. Please press star 6 to unmute yourself. Then slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
My name is Lurleen Rover. Lurleen, L-E-R-L-E-N-E. Last name, Rover, R-O-E, V as in Victor, E-R. Good afternoon, all. I will be brief and concise. I spent 27 plus years locked up for a horrible crime that I did not do. 3 years of that was spent in jail, going through 3 district court trials. When I finally got to the federal courts, I had no clue what to do, but I finally got help from a friend to do a writ. It was so well done that the federal court judge refused me counsel. But by the time that the federal AG responded to my writ, my helper had passed away, and I had no idea what to do, and I still don't. Anyway, I keep hoping for a television show or someone to be interested in my case to help with forensic testing, etc., that was never done, and that I certainly can't afford. By that time, I'll probably be dead. So if it is important to me that my children could receive compensation for the years and years without their mom, stuck in the state system for so long. By the time my name is finally cleared, it'll be too late for me, but not for them. I am not insignificant or a useless nobody, and neither were they. They deserve the compensation that I most likely will not be alive to see. I am on parole, have been successfully for 2 years, but I also live in fear of being sent back to prison if I personally complain about my own circumstances or the unfairness that happened to me. But after I'm dead, I would like to know that my kids' lives will be better than they were all those years that they were apart and that we were torn apart as a family. I thank you very much for listening to me.
Thank you, caller. And with that, Chair, there are no more callers to provide neutral testimony at this time.
All right, thank you so much. That concludes testimony On AB 104, do you have any concluding comments? Please go ahead, Assemblyperson Yeager.
Steve Yeager for the record. Thank you, Chair. Just a couple of points I wanted to make. Some of these issues came up in the Assembly Judiciary, and the first one is about compensating people for basically pre-trial incarceration. And I think as a policy, as a state, we just don't do that, generally speaking. A lot of people are incarcerated and then go to trial, and when they are acquitted, of course, they're free to go. But I think as a state, we've decided that we don't compensate for that. Maybe we ought to, but this bill I don't think is the place to do it. So I've still resisted those efforts for pre-trial. And then, I had a very productive meeting with Ms. Brown the other day talking about posthumous exonerations. And what I told her and what I'll say here is I think the intent of this bill, as you heard pretty clearly, is to help the individual get back on his or her feet once released from prison. Now, obviously, there's a lot of pain and suffering for the families of those individuals, but as of now, that's what the bill is aimed towards. I think there's always an opportunity in the future if we have these situations where there are posthumous exonerations to perhaps look at that policy and decide where we want to go, but I think for now, it makes sense to keep it where it is. I respect Ms. Rasmussen's position on the bill, and I'll continue to kind of work on some of that language because I do think there is potentially an injustice there if your conviction gets overturned, but maybe you're incarcerated still for another year or so. So I will work on that and get back to the committee with any potential amendment. And again, just want to thank Ms. Proctor and the Attorney General's office. They've been wonderful to work with on this bill, and they've really been doing great work in making sure that people get compensated and they get compensated quickly and fairly. So I want to recognize them. Thank the committee for your time and would urge your support for Assembly Bill 104 in its first reprint.
Thank you. It looks like we have another question from Senator Pickard. Go ahead.
Just a quick question. My understanding is this is the intermediate piece. There's still civil penalty, or not penalties, but civil damages that can be awarded. And there's still an availability to pick up that time that wasn't captured in this, correct?
Steve Yeager for the record. I think you'd be correct, Senator. As indicated, most of these individuals will file federal 1983 actions where, frankly, the recovery is usually larger than what we're giving out in the state. So I think that would potentially be captured there. The piece I don't know, I'm not going to say this is true or not true. I don't know if a family member can bring a 1983 on behalf of a deceased person on a wrongful conviction basis. So I had a conversation with Ms. Brown about that. I don't know the answer, but I'll look into that as well. But you're absolutely right. This is the first step of potentially at least two steps.
Thank you.
All right, thank you so much. That concludes the hearing on AB 104. That hearing is now closed. We will open the hearing on AB 396. No, we will not. We will open the hearing on Assembly Bill 394.
Steve Yeager for the record. I promise this one will be quick, Madam Chair. Thank you, Chair Scheibel. Thank you so much, members of the Senate Judiciary Committee. I'm Assemblyman Steve Yeager, representing Assembly District 9 in Southwest Las Vegas. Before you is Assembly Bill 394 in its first reprint. I should also note there is a small amendment that was submitted. You should have that on Nellis. Just by way of background, before we get into this bill, as you may recall, last session we passed a provision in Assembly Bill 236, which was the big criminal justice reform bill. That provision directed the Commission on Peace Officer Standards and Training, commonly known as POST, subject to available funds to develop and implement a behavioral health field response grant program. The purpose of this bill in front of you is to improve responses to people in crisis by allowing behavioral health professionals by telephone or video to assist law enforcement to de-escalate, stabilize, and resolve crisis situations. In other words, this bill sets up and allows a program for mobile crisis teams to operate via video or phone. Now, going back to Assembly Bill 236, we set up a program, but there wasn't any funding specifically allocated to that behavioral health field response program. We fortunately, very fortunately, identified a funder who is interested in investing in a program like this in the state of Nevada through a multi-year grant. To prepare for the likelihood of securing this funding, we reviewed our statutes and believe that including immunity for mobile crisis response team members is important. Assembly Bill 394 would provide immunity from liability to encourage certain behavioral health professionals to participate as members of a mobile crisis response team. We do not want them to be a part of this crisis response team. Actually, we do not want them to not want to be a part of this due to concerns about liability. Now, you'll see with the amendment, we did some tweaking to make sure we're identifying the right professionals who are going to be potentially engaging in these services. So we took out physicians generally, but we have psychiatrists, both of the MD and DO variety, and then also the other individuals listed there. So immunity in these cases would only extend to the situations where that person is acting in good faith and their actions are not considered to be gross negligence or willful wanton or intentional misconduct. So this is not blanket immunity, it's narrowly tailored immunity. There is currently no statutory definition for mobile crisis intervention services in our state. AB 394 makes clear what those services are by providing a definition of mobile crisis intervention services. You'll find that on page 2 of the bill, line 16. These types of services are really important because they support law enforcement with complex behavioral health situations that they sometimes are not fully trained to handle. This model can reduce the number of involuntarily mental illness holds and hospitalizations, divert people from jail, and promote voluntary participation in treatment services, which we want to encourage whenever possible. Having the help of behavioral health professionals can also reduce the degree of the crisis and can result in fewer adversarial and confrontational episodes faced by law enforcement. Now, to answer a question that I think would probably be coming, the details are still being worked on this program, but I'm envisioning that we'll probably have a pilot program to do mobile crisis intervention, and that will probably mainly be focused on our rural communities to start, just because the nearest behavioral health professional might be hundreds of miles away and it's just not practical. So the way that this would work is the officer would actually arrive at the scene and have an iPad where they would be able to connect with a behavioral health professional, and if they responded to someone in need, they'd be able to really just hand over the iPad and let that professional talk to the person and make a recommendation about whether that person needs to go to the hospital, whether they're willing to go home, whether they need to go to jail. So it really is a tool for the officer to hopefully not involve that person in the justice system or in the healthcare system if they don't need to be. So stay tuned for further details. I think I've said about as much as I'm at liberty to say at the moment, but I'm excited about the possibility of this program and what it could mean for our state. And I think it's important that we pass this bill to make sure we have the providers who are willing to actually do these services. With that, Chair Scheibel, members of the committee, I'd be happy to answer any questions.
Thank you so much. I am likewise excited for this program, and I hope that we will see it come to fruition very soon. Questions from members of the committee? I don't see any questions. All right. We will then move to testimony in support of AB 394. I don't see anybody in the room to give support testimony. I do see someone in the room to give support testimony. Come on down.
Tanya Brown, Advocates for the Inmates and the Innocent. We would support a bill like this. I think it would be beneficial for all. To de-escalate the situation would be a good example of controlling police brutality, someone being injured, someone dying. And I think that social workers, those types of individuals are better well equipped to handle these types of situations and not law enforcement. So yeah, we would support this. Thank you.
Thank you. I don't see anybody else coming up to the table in support, so we will go to the phone lines for support testimony on AB 394.
Thank you, Chair Scheibel. To testify in support of Assembly Bill 394, please press *9 now to take your place in the queue. Once again, to testify in support on AB 394, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to provide support testimony.
Okay, we will move then to testimony in opposition to AB 394. I don't see anybody coming to the table in the room, so we will go directly to the phones, please.
Thank you, Chair. To testify in opposition on Assembly Bill 394, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 394, please press star 9 now to take your place in the queue. And Chair, there are no callers to provide opposition testimony at this time.
Okay, thank you, Mr. Kyle. We will move to testimony in the neutral position on AB 394. Again, I don't see anybody in the room coming to the table to give testimony, so we will go directly to the phone lines, please, in neutral on AB 394.
Thank you, Chair Scheibel. To testify in neutral standing on AB 394, please press star 9 now to take your place in the queue. Once again, to testify in neutral standing on Assembly Bill 394, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, thank you very much for your help. Then that concludes the hearing on AB 394. I will now close the hearing on AB 394. I will open up the hearing on AB 30 or 43. AB 43, let's do 43 first, sorry.
Chair Scheibel and members of the Judiciary Committee, good afternoon. I'm Keith Lee. I'm here today on behalf of the Nevada Judges of Limited Jurisdiction, which is the association comprised of most of the justices of the peace and the municipal court judges in the state of Nevada. I'm here to present reprint run 1 of AB 43. By way of quick background, AB 43 was sponsored by the Assembly Judiciary Committee on behalf of the Nevada Supreme Court at the request of the Nevada Judges of Limited Jurisdiction to address some concerns that the judges had with respect to some procedural aspects of the Nevada Judicial Discipline Commission. As you can see, reprint 1 completely deleted the bill and requests that the Nevada Supreme Court study and make recommendations concerning the procedural and substantive statutes and rules of the Judicial Discipline Commission, and to gather some statistics with respect to that, and then to report back to the legislature. I don't want to put words in the mouth of Chair Yeager, and he is certainly here to speak up. But I think the very quick background of where we got from where we started to where we are today is that, given some discussions that the chair and other folks have had with respect to the bill, it became clear that the bill was very complex. There are a lot of issues that need to be resolved, and we simply couldn't do it within the time frame of the legislative session, particularly given how busy both your committee is and how busy the Assembly Judiciary Committee is. So Chair Yeager, in consultation with Chief Justice Hardesty, in consultation with our organization, and in consultation with a number of other stakeholders and interested parties, determined that, as we see in reprint 1, the best way to go is to request the Supreme Court to study this and to report back to the legislature. With that, Chair Scheibel, I would urge the committee to process the bill as it is and to support it on the floor. And with that, I'll try to answer any questions that any of you may have. Thank you.
Thank you. Are there questions from members of the committee? I just have a brief question that I understand that the Supreme Court undertakes studies like this on a relatively regular basis, and so can you just describe what the report is that they ultimately produce for the legislature? Is it the same? Sorry, my question is it the same as what they would do in any other study, or are we asking for something different in this report or at the conclusion of this study from what they normally do?
Thank you, Chair. Keith Lee for the record. I think it's what we'd expect. By way of very quick background, way back in 2006, Chief Justice Rose convened what we now refer to as the Article 6 Study Committee, and that resulted in several suggestions to the legislature that were adopted in, I think, 2009. And so the report would be the same. It would be a report that would come back to the legislature, very similar to the first Article 6 Commission report way back in 2009, I believe.
All right, thank you.
Thank you.
And I don't see any other questions, so we will move directly to testimony in support of AB 43. I don't see anybody coming to the table in person, so we will go to the phone lines. Support testimony on AB 43.
Thank you, Chair Scheibel. I apologize, connection issue. To testify in support on Assembly Bill 43, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 43, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide support testimony.
Okay, we will move to testimony in opposition to AB 43. There is nobody present to give testimony, so we will go directly to the phone lines, please, Mr. Kyle.
Thank you, Chair. To testify in opposition on Assembly Bill 43, please press star 9 now to take your place in the queue. Once again, to provide opposition testimony on Assembly Bill 43, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Okay, we will move to testimony in the neutral position on AB 43. Again, nobody present in the committee room to give such testimony, so we will go directly to the phone lines in neutral on AB 43.
Thank you, Chair. To testify in neutral on Assembly Bill 43, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 43, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 946, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon. My name is Valerie Carter, VALERIECARTER. Good afternoon, Madam Chair and members of the committee. My name is Valerie Carter. I'm a management analyst with the Nevada Commission on Judicial Discipline. I just wanted to note for the record today that the Commission's Executive Director and General Counsel, Paul Dyla, did want to attend today's hearing on this bill, but unfortunately he could not attend as he's currently on a plane. So instead, he has submitted his written testimony regarding AB 43, and that can be found in Nellis. If any of the committee members do have any questions or concerns that they would like to discuss with Mr. Dyla, please do let us know, and he will make himself available after today's hearing. So with that, I thank you, Madam Chair, for your time, and thank you to the committee.
Thank you, caller. And with that, Chair Scheibel, there are no more callers at this time.
Thank you so much. That concludes our hearing on AB 43. I will close the hearing on AB 43. Thank you, everybody who joined us today for the first 4 bills. And we have one more bill on our agenda. We have AB 30. I would like to go ahead and open up the hearing on AB 30. I believe indeed we do have Ms. Davis on the phone, and we have Ms. Meiske here in person if you want to come on up to the table. And I will leave it to you to tell us what order you're going to present in.
Good afternoon. I'll start and then turn it over to Ms. Meiske when I complete the initial presentation. Mandy Davis, Deputy Administrator for the Division of Child and Family Services. I'm here to present AB 30, which revises some areas related to the account for aid for victims of domestic violence. The account for aid for victims of domestic violence receives funding through a portion of the fee for marriage licenses sold throughout the state. The funds are used to support nonprofit community providers of services for victims of domestic violence. Funds are split between counties based on current population totals and are then split between providers in those counties with more than one eligible provider through a review and scoring process of their grant applications. Assembly Bill 30 makes a few changes to the program that awards funds to nonprofit providers in the eligibility requirements to be able to apply for those funds. One of the requirements is that this bill changes would be that the nonprofit organization provides its services exclusively for victims of domestic violence if they are located in a county whose population is 100,000 or more, so currently Clark and Washoe, and then that it provide its services primarily for those victims if they are located in a county with a population less than 100,000, so all the rural counties. This would allow providers who maybe offer some other types of services that are not just for victims of domestic violence to also be eligible to apply for those funds if they wish to do so. Existing law requires that an allocation of 15% of all money granted from this account to organizations in a county whose population is 700,000 or more, so Clark County, to an organization that they specifically assist victims of sexual assault. Section 2 renames the account as the account for aid for victims of domestic or sexual violence to reflect the authorized use of these funds. AB 30 also changes another one of the eligibility requirements for entities to apply for a grant from this account from the requirement that the nonprofit organization be able to provide or make referrals for counseling for victims or spouses of victims and their children. And then it changes the word spouses to partners and their children to family members. So it expands some of the relatives and family members that are related to that victim. In addition to the requirement that the nonprofit organization be able to provide education and training, AB 30 also adds a requirement that they be able to provide prevention programs related to domestic violence to members of the community. Finally, currently there's no limit to the number of awards that can be issued in a county or statewide. Section 2.5 of the bill requires that the administrator of the Division of Child and Family Services award grants to no more than one applicant in each county whose population is less than 100,000. Currently, we don't have any counties with more than one eligible provider who regularly applies for this funding source, so that would not have a significant change on the current operations or the awarding of those grants. The Division of Child and Family Services will be able to implement the requirements of this bill without any additional resources or funding. And then with that, I will turn it over to Ms. Meiske from the Nevada Coalition to End Domestic and Sexual Violence to provide a more in-depth overview of what these funds go towards supporting.
Good afternoon. My name is Sue Meiske. I'm the Executive Director of the Nevada Coalition to End Domestic and Sexual Violence, the statewide coalition of domestic and sexual violence programs in Nevada, and I'm here today to express our support for AB 30. This bill may look a little familiar to this committee. There are some changes that are also included in another bill. This bill does not have any fee increases, so this is only about changing some of the processes to make the process work better. For those of you who are not familiar, there are 14 domestic violence programs serving all 17 counties in the state and one standalone sexual violence service provider in Las Vegas. They each rely on grants from the account for aid to victims of domestic violence, which is funded by a surcharge on every marriage license sold in the state. 6 of the 14 domestic violence programs also, to the extent they are able, provide sexual violence services, but they receive no state funding for that critically needed, important work. The recipient organizations range from large multi-staff agencies in Clark and Washoe counties to small 2 to 3 person operations in communities like Elko, Fallon, and Winnemucca, to an all-volunteer program in Battle Mountain. While each program is a private nonprofit organization, they are all dedicated to serving survivors of domestic and/or sexual violence in their communities. Last year, programs reported serving more than 21,000 individuals on hotlines, in shelter, and through advocacy and support services. Even through the COVID pandemic, services continued, with significant increases in both hotline calls and shelter bed nights. Importantly, in some of our rural communities, the domestic violence response function is one portion of a local nonprofit that provides multiple social services because they are the only game in town. For this reason, the division approached providers several months ago about the need to change the statutory language from exclusively serving victims of domestic violence to primarily, as you see in the bill. The large counties and the small counties had different reactions to this language change. For programs in larger counties which receive enough funding to be able to specialize in domestic and/or sexual violence, the exclusive language works, and they had concerns that the language change might have some detrimental impacts. The broadened language might result in DCFS receiving technically eligible applications from organizations that, while providing some domestic violence services, do not specialize their focus on this population. This raises the concern about quality and depth of services to these populations, and also endangers, from a financial perspective, full-service programs who are already struggling to meet the needs in their community. On the other hand, for some rural programs, not making the change could jeopardize their access to these funds, as they cannot at the same time deliver services that have been asked to be taken on by their communities and meet the exclusive statutory language. Also, the cost efficiency of delivering a few services from one organization makes up for the lack of economy of scale the rural programs experience. Over a number of months, we were able to come to a consensus around this issue, keeping the exclusive designation for counties over 100,000 and changing to primarily designation for counties under 100,000. Part of that agreement was based on limiting the number of programs that could be funded in the smaller counties, so as not to create a situation where several programs are vying for very small amounts of money and essentially ending up with not enough money for any service. And then, after having spent many hours reviewing the section of the NRS, several other changes were suggested that reflect a broader understanding of relationships and the need to address not only intervention services, but also prevention. What we now know is that many of the individuals who are in need of counseling as a result of domestic violence may not be spouses, and that family members may extend beyond children. In addition, while we want to ensure that intervention services are available, we also want to encourage programs to develop and implement prevention programming so that someday we see the end to this epidemic. While it took some time, we were able to reach the consensus you see before you in AB 30, and I want to thank you for your time, and I'm open to any questions, and I hope that you can support this bill. Thank you.
Thank you both so much for your presentations. Are there any questions from members of the committee? Go ahead, Senator Pickard.
Thank you, Madam Chair. First, thank you for the service that you provide. It's critically important. Too many of my clients are participants in your program, and I would love to see that part of my client base go away. That said, I'm a little confused. I'm supportive of the concept, but we seem to be in Section 1 in the opening statements expanding the account to include sexual violence. And then as we progress down to sub 4, we seem to be limiting it still to domestic violence. And I understand you spoke a little bit about the tug of war over the funds, the small amount of funds that are there. But it seems to defeat the purpose of expanding the title of the account and then not expanding the services that are provided by that account. Can you explain why we expand the title, or the title, the name of the account, but then we don't look at the victims of sexual violence or those programs that are presumably providing services to both of those communities?
So for the record,
Go ahead, Sue.
Sue Meiske. The current statute has funds, the funding is provided for domestic violence services, and in Clark County, 15% of the funding goes to sexual assault. That's the current language. So the division wants to add sexual violence into the title because they're currently funding a sexual violence service. This particular bill does not change the fact that it will only fund one sexual violence program, right? Or one county will receive funding, right? All the rest of the counties will not receive any funding for sexual violence services because this bill does not increase any funding. So I hope that explains it. They're adding the sexual violence to account for what's currently in the statute, and not expanding services without funding.
All right, Ms. Davis, did you want to add?
Mandy Davis for the record. No, I was going to say the same thing, that currently we allocate 15% in Clark County to sexual violence programs. So this would just change the name of the account to reflect that as well.
All right, I appreciate that. And what I want to make sure we don't do is, and if that, and what I'm hearing is that appears in a different section of statute that we're not amending here. I just wanted to make sure that by changing the language under Section 1 Sub 4A to exclusively for victims of domestic violence, we weren't undoing that expenditure for the sexual violence piece. But if that's in a different section, we're not amending that, that stays intact, I'm fine. Thank you.
All right, any other questions? I don't see any questions, so we will move on to testimony in support of AB 30. I don't see anybody coming forward in the room for support testimony, so we will go to the phones, please, Mr. Kyle, in support of AB 30.
Thank you so much, Chair Scheibel. To testify in support on Assembly Bill 30, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 30, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 648, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, John Jones, here on behalf of the Nevada District Attorneys Association in support of AB 30. The domestic violence programs around the state do critical work on behalf of the victims of domestic violence, and we appreciate all of their efforts. And we just wanted to get on record in support of AB 30. Thank you.
Thank you, caller. And with that, Chair, there are no more callers to provide support testimony at this time.
Okay, thank you. We will move to testimony in opposition to AB 30. Again, I don't see anybody in the room to give testimony, so we will go directly to the phone lines, please.
Thank you, Chair. To testify in opposition on Assembly Bill 30, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 30, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
Thank you so much. We will then move to testimony in the neutral position on AB 30. Not seeing anybody present in the room, we will go to the phones.
Thank you, Chair. To testify in neutral standing on Assembly Bill 30, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 30, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, then. That concludes the hearing on AB 30, unless you guys have any closing remarks. Okay, then. I will close the hearing on AB 30. Thank you so much for your patience, for sticking with us through the end of this committee meeting to present AB 30. I'll now move to public comment. I see somebody here in the room to give public comment, so you may go first, and you will have 2 minutes.
Tanya Brown, Advocates for the Inmates and the Innocents, thank you. We heard Ms. Rover speak, and I believe that she had a little problem with how this works, the telephone. She meant to testify under opposition and not neutral. Okay, so I just want to clarify that.
Thank you.
And then she had mentioned something, and I just kind of want to touch on kind of what I do as for an advocate for the inmates and the innocent. Besides trying to get laws created that better help them and help to seek their paroles, exonerations, and other things, what betters them. Okay, I also do other things too for the innocent, and that is sometimes I'll take it upon myself, and others will take it upon themselves, and we will look into cases. And when she had talked about that TV show, I actually provided her case to Reasonable Doubt Show, and they called me about 2 years ago. They actually wanted to consider they were going to take her case on. But in order for that to happen, they had to speak with her. I did not know, because I had not spoken to the woman, never really spoken to the woman in years. And so it turns out that they have to contact them, and then they said they contacted her, but she was no longer. Apparently she had been paroled. That's the reason her case has not already been seen. But there's no doubt in my mind that Ms. Rover is in fact innocent of this crime. And it explains a lot, although she's had 3 trials. And I could tell you that we get this a lot with those who maintain innocence. You hear with the courts will go on appeal. And the stuff that cries for a resolution in their petitions and on appeals do not get addressed. They're overlooked. They're totally disregarded. And especially if it proves innocence. And then if you're lucky enough and you get into the federal court and they actually look at it, like in her particular case, the AG's office, like I said, they filed a motion, and she didn't know how to answer it. In fact, she wasn't even going to do a petition. Her actual appeal was filed within the timeline, within 2 days. Otherwise, she would have lost all appealability for everything. And I actually managed to find someone to help her. Made it through the process all the way to the federal court, and then the person passed away. And she's stuck. So without a TV show to exonerate her, and this is something that we do. So it's not just, there's other things. I just wanted to mention that. Thank you very much.
Thank you. I don't see anybody else present to give public comment in person, so we will go to the phone lines, please, for public comment.
Thank you, Chair Scheibel. We are currently on public comment this afternoon. If you'd like to provide public comment at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits, 556. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT, sister of Thomas Purdy, murdered by Reno Police and Washoe County Sheriff's Office. Today I'd like to talk about 2 people that were killed by local law enforcement in your state. Jose Luis Dominguez was 47 years old when he was shot and killed by Sparks police officers Ryan Patterson, Corey Foster, and Scott Bader 2 years ago today. In DA Chris Hicks' typical MO, he did not release his usual justification of the shooting until August 21st, 2020. The officers literally were in an armored vehicle when they shot Jose. Those who knew Jose loved him and were blessed with his generous spirit. He loved deeply, and loved his family was the utmost importance to him. He enjoyed cooking, working around his home, playing horseshoes, and watching his 49ers and Giants play. Washoe County Sheriff's Office took the lead on the independent investigation. They are the same agency, along with RPD, who asphyxiated my mentally ill brother in crisis. Police investigating police is not transparency and accountability. 15 years ago today, 36-year-old Aaron Jones was killed by LVMPD. After being confronted by officers near Sahara and Durango Drive, he allegedly tried to ram a police car and started driving towards officers. he was shot. At the coroner's inquest, questions were raised about whether the officers were truly in danger when they fired their weapons. Armored vehicles, hollow point bullets, rubber bullets, CS gas, helicopters, stab vests, tactical robots, de-escalation training, CIT training. We have given it all to police, and they are still killing community members. Please support bills that promote transparency and accountability. If law enforcement oppose a bill, I ask that you support it. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide public comment at this time.
Thank you so much for your help, Mr. Kyle. That concludes today's meeting. We will be meeting again tomorrow at 1 p.m. And until then, we are adjourned.